Hi, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. We do estate planning and we do probate. As always, if you want to reach out for a strategy session regarding estate planning or probate, you can contact me at njestateattorney.com. So I wanted to go over something that's a little interesting, actually, that I'm seeing as I do. I'm meeting with clients, and there's some family issues, and I thought it was important to talk about. So I wanted to talk about disinheriting a spouse and or a child. So basically, you cannot disinherit a spouse. So it goes back into all this intent, but the long or the short of it really is marriage is a partnership, and you can't get rid of that. If you're still married when you pass, you can't just say, okay, goodbye, like everything's going to our children, you get nothing. Your spouse is still entitled to something because of the marriage. And state of New Jersey laws basically indicate certain percentages that go if you don't have a will. Well, that's intestacy, but this is you do have a will, excuse me. So they indicate how much the surviving spouse takes. So you really can't disinherit a spouse. However, you can disinherit your children. And I see this in a lot of examples of when I start talking to the families a little bit more, they have older children, and by older I mean probably in their teens or college, maybe a little older, not really, and they're unhappy with their life choice, with their child's life choices. They're unhappy with their child has a drug issue or an alcohol issue, maybe can't handle finances well, and they go, you know what, we just can't support this. They don't want to do a trust to protect the interests, but so they basically say, look, I'm just not giving them anything. Or even with much older clients, you see that there's a child that's kind of estranged over time, that they're not really talking to, or has kind of just deserted the family. They don't want to leave things to them. So in your will, you need to be specific. And usually my wording is elaborate. I basically want my client to understand that in this will, you've omitted John Doe, and this was intentional. I was of sound mind, not under duress or undue influence at the time of making this and putting all this information together, and you have purposely been left out. That's really the long and the short of what my wording is. Other attorneys like to use short language, like this was an intentional omission, but it's key that it's evident. Just by not naming the person, it doesn't make it all go away because they can challenge it. You really want to try to make this not challengeable. And by saying this was an intentional omission, the court and your beneficiaries and the disinherited child understand that, look, I purposely did this. This was my choice, nobody else's, so deal with it. That's really it. So just to tie this up with a nice little bow, you can't disinherit a spouse, but you can disinherit children. If you disinherit children, be specific in it. Say that it was an intentional omission, and you weren't under duress or undue influence, and you were in your sound mind at that time. So that's it. As always, if you found this video helpful, if you could hit the like button on our Facebook page or our YouTube page, subscribe. We're putting out content daily. If you know somebody that could benefit from this video, please share it with them. Let them know you were thinking about them. And if you have any questions, want to do a strategy session with me, I'm David Campanile, owner of Campanile Law, located in the great state of New Jersey. We do strategy sessions for estate planning and probate. contact me at njestateattorney.com.